Hi, everybody. Thank you for coming to Hot Topics in Food and Beverage Law. My name is Bob Heinrich. I am a business attorney here at Brainhards. I focus on financing transactions, things like lending arrangements and other kinds of debt and equity raises, along with general corporate consultation. I am also chair of Brainhards' firm-wide multidisciplinary food and beverage team. I got my start in food and beverage primarily by drinking a whole lot of beer. And when I say a whole lot of beer, I mean a whole lot of beer. I like beer. It's easy to drink beer in Wisconsin. We are, of course, one of the top beer-producing states. But we're not just beer. We are a big deal nationally when it comes to the broader food and beverage space. And as such, our food and beverage team has attorneys essentially from every practice group here at Brainhards. Our team is well represented. We assist all types of F&B clients, from small startups to companies that are emerging to the more well-established companies that you would have heard of and bought stuff from at the grocery store. We deal with formation issues relating to investors, as well as sales and purchases of businesses. We'd have that covered too. It's not just the transactional side of things, though. Our team has people who know the ins and outs of all the food safety regulations, product recall, litigation, intellectual property. Like I said, pretty much every practice group. So with that, the commercial has ended. I will hand it over to Jess Polakowski and Guy Temple, who will be talking about FDA inspections. And just before we begin, I'd like to say, please ask questions. Lawyers, you may or may not know, really like to talk, so break it up, ask questions, be more informative and entertaining that way. So with that, hand it off to Jess and Guy.
So I'm Guy Temple. I'm one of our litigation attorneys here in Milwaukee. And Jessica Polakowski is one of our litigation attorneys in Madison, and both of us together work on food safety issues with food manufacturing clients, food processors, and related entities. And so we're going to be talking today about FDA inspections. But before we get started on that, how many folks here are with a company that has a food processing or food manufacturing facility? Okay, great. So I want to make sure I knew who our audience was here that we're talking to. I know there's some folks who are with related industries. We're going to jump right into this here and talk first what we're looking at with the FDA under the new administration. Sure enough, I've got the remote here. So first off, the President has named a new FDA Commissioner. He was confirmed on May 11th. It's Scott Gottlieb. This is the former Deputy Commissioner of the FDA for Medical and Science Affairs under George W. Bush. And like the previous FDA Commissioner, Commissioner Gottlieb is his background is in drug and medical devices. He's a practicing physician. He's been a drug company consultant. So he's pretty much a known quantity to the drug and medical device, biotech industry, but not so much to the food safety industry. In his testimony before Congress, part of his confirmation, he expressed support for the Food Safety Modernization Act, which those regulations were moving along and implemented under the Obama administration, and enforcement of FSMA, as it's called, had been moving along and ramping up under the Obama administration. But there's still a little uncertainty as to how the new administration is going to handle food safety, and most importantly, how much of an emphasis they're going to place on it. There's a couple of reasons to doubt that. The federal hiring freeze, although the FDA is no longer subject to that hiring freeze, there is talk about reducing the number of food safety inspectors. The new commissioner has also realigned inspectors recently and made clear that they'll now be specialized on areas of inspection rather than based on regions. And then the proposed budget that President Trump has put forward, initial review of it showed possible reductions to FDA's food safety coverage, food safety programs. So while there hasn't been a lot of public comment, it's going to be an uncertain landscape for enforcement, particularly where we have been advising clients for the last several years that there was an increased emphasis on food safety from the FDA and from the White House. We're not quite sure what to expect now under the current administration.
And go ahead. First of all, I'm Jess Filikowski. I'm a litigation attorney in our Madison offices of Brainhards, as Guy mentioned. I am here in the food and beverage group. I help out our clients with recalls. So to the extent that we have recall issues that arise, to the extent that recall issues turn into litigation and litigation-related issues, that's what Guy does as well. So welcome, and feel free to interrupt us at any time with any questions. Don't wait till the end. FDA inspection. What do you do when the FDA shows up at your door? First of all, the question that I always have people ask me is, can they do that? What's their authority? Can they just come in and expect to walk into our facility? The answer is yes. There is statutory authority. The FCCA, Section 704, provides that authority. There's also authority within FSMA that heightens their ability to come in and take a look at your facility. It does matter, though, when they show up, of course. If they show up at peak times or different, if they make it very difficult for you, you can politely deal with it, although it probably best not to tell them that they can't come in. Time, place, and manner do matter, but minimally. The reasons that the FDA can come in and inspect your facility are variant and wide-ranging. So they can come in of course, for criminal reasons, if they suspect criminal activity, but they can come in for routine reasons, for cause, pre-approval, compliance. It really runs the gamut. The short answer is, if they want to take a peek, they can take a peek. They don't need your consent. They have authority to come in without. And certainly, if you tell them no, they will go get a warrant. It's not too difficult to do. So what do you do when the FDA shows up at your door and you know that they have the authority to be there?
So one of the most important things is to be prepared with a written inspection manual. And if there's one takeaway from what we'll say here today is if you don't have a detailed written inspection manual covering the things that we'll discuss, you need to work through that and have that put together, and Reinhardt is happy to work with you on that. But that inspection manual, first and foremost, should include a list of the members of your inspection team, should identify everyone who is going to be notified and involved when there is an FDA inspector at your door. And at the top of that should be the designated individuals who are going to be the primary FDA liaison when they arrive at the door. You should probably have a primary and a secondary designated individual, and coordinate vacation time to make sure that one of those people is always there, or at least always available to coordinate with the FDA if they come and show up on a surprise routine investigation. That manual should also include company inspection policy. You should think through a number of questions on how you're going to handle certain parts of the inspection and have that in a policy so that your inspection team can state to the FDA inspectors, it is our policy on this to do X. So there's no questions. That should include policy on affidavits. We'll get into that in a moment, but it should be not to sign anything while the FDA is there. Policy on photography. There's a lot of pressure from FDA inspectors to come in and take pictures. They don't have clear legal authority to do so, as we'll get into in a moment. And the best thing you can do is to have a policy on whether or not they're allowed to take pictures in your facility. Questioning of employees. Direct your employees about answering questions, how to handle questions. And specifically, if there's certain employees that are not able to answer questions, the best thing for them is to be able to lean on company policy that says that they can't. Policy on trade secret and confidential information. So the important thing is to have identified what trade secret and confidential information might be visible and available to inspectors, whether they're reviewing your records or moving around your facility, so that you can properly identify to inspectors when they're there what is trade secret and confidential, and you can have it labeled as such. We'll talk in a moment about why that's so important. And then finally, laying out access to company records and what your policy is on that. You should direct members of your inspection team on what records are accessible by the FDA and what records are not. There are certain records that they are allowed to look at. That's going to be records, related to safety matters, testing, sampling, all of those things, but not necessarily personnel files, pricing details, recipes that may be trade secret. So there's some items they're not going to be able to view, but they're going to ask to see everything. And investigators, as they're called, inspectors, are trained to go ahead and ask to see everything, whether they have the statutory authority to do that or not. And so your inspection team needs to be prepared to push back where they can push back.
Absolutely, and the best comfort that you can give your employees to pushing back is to say, we have a policy that covers that. When procedures for responding to the arrival of an inspector, first thing that someone who, even the receptionist sitting at the door when the inspector walks in, she or he needs to be able to pull that out and say, who do I call? Who do I call and what do I say? Down to some of the policies we've looked at are very detailed. Call this person at this number. If they're not available, call this person at this number. The worst thing that a person can do is panic. And if there's no policy that governs, then panic is understandable. So best thing you can do, have a policy, have it written down, and make sure that people are aware of it. And that last part is key as well, because if you have a policy and nobody knows about it, it doesn't do you any good. So who do you call? Procedures for arrival. Who do you call? What do you tell them? What do you do with the inspector while the inspector is waiting? Do you direct them to sit in the lobby? Do you, it's down to that level of detail. What do you tell the inspector? I'm getting in touch with so-and-so. Please wait here. Do you direct them to a certain location? Very detailed. Again, from my perspective, the more detail in the policy, the better. The instructions for resolving before and after. So if during the course of the investigation, an investigator asks a question, they're going to want an answer. But if the policy says do not provide an answer or do not allow questioning of employees at this time, then the answer to the investigator is likely going to be, we'll have to get back to you on that. Our policy is that we don't answer questions during investigation. And that's fine, so long as there's a policy to lean on for that.
And the most important thing is just making sure your employees are comfortable, your inspection team is comfortable with what they can and cannot do. Because again, the FDA investigators that arrive there are going to push for everything that they can possibly get to make their job easier. And so your team needs to know where to push back, because the FDA is not going to necessarily limit themselves in what they ask for.
Absolutely. The purpose, sorry, go ahead.
How often does this happen?
More often than you would think. I had a client who had, through no fault of their own, but through distributor issues, actually had a series of 2 recalls over the course of a 3 or 4 month period. And probably no surprise to anyone, that prompted an FDA visit within the month. So it's something like that. If you file a reportable food registry report, that might prompt an audit, or it may just be totally unprompted. So
how often? You see these guys once a year, once every 5 years?
So going back to the types of inspections, under FSMA, the goal is to have FDA in doing routine inspections of every food processing facility that's subject to that law within the rollout over the next couple of years. So if you've not been inspected in the last several years, the guidance is that you can expect to receive a routine inspection. But the other possible types of inspections that we talked about, for cause is going to be if there is a complaint from a customer, consumer, if there's a complaint from a competitor about a food safety issue, pre-approval if there's a particular product that you are seeking to introduce and you've got to get approval, the FDA is going to come in and do an inspection, pre-approval on that. Compliance is going to be if they discover something on a routine inspection and now they're looking for you to fix it, they're going to come back in. But the routine inspection, I want to say that the numbers, it's thousands a year, and I don't have the numbers in front of me, but those have accelerated under the FSMA Act over the last 5 years. I think they've conducted more each year. The goal is to have inspectors in over the next couple of years in every food processing facility in the country that's subject to the Act.
And this is probably obvious, but there is guidance under FSMA that suggests that once an investigation occurs, if that investigation is clean, if there are no issues arising from it, there is the inspections that will occur from that point forward are allowed to be more variable in time. So, of course, if you have any issue, you can expect a follow-up visit. And in fairly short order. But FSMA does give inspectors, investigators the leeway to, if you have a clean facility, you don't have to go there every month. You don't have to go there every year even.
And so a couple other things before an inspection, making sure your house is in order. We'll talk about record keeping, but making sure that your records are well organized and accessible, and that your inspection team knows your manner of record keeping, knows how to access things that the FDA is going to ask for, and conducting mock inspections and self-audits. This is so important, if you can do this, to have your inspection team do a mock inspection of the facility themselves, come in just like an FDA inspector would go through, run through all of the procedures, all the way from greeting someone at the door, finding a location to meet with them at, and handling all of the walkthrough, the records access, so that your inspection team is not caught off guard. There may be some occasions in which you receive notice about a routine inspection. More often, it may be that they're simply showing up at the door. It's a routine FDA inspection.
Another important point on this front in keeping your house, making and keeping your house in order, is make sure that you review your policy. Once you have a policy, you can't just put it in a drawer and leave it for 5 years, because we all know we have turnover. So you may have contacted these people, and none of these people are at the facility any longer. So it's important that you do a regular review of your policy as well.
So the things that the investigators are going to do before arriving for an inspection, they're going to be looking at your company history, compliance program guidance, and registration and listing information, public info about your company. They're going to have equipment for sampling, examining pre-printed seals, etc. So they're going to be very well informed and prepared about your company before they arrive, and you need to make sure that your inspection team is as familiar with everything as the FDA investigators are when they arrive at the door. So what to do when they arrive at the door?
We talked a bit about greeting an inspector. This all goes into what goes into the policy. Greet the inspector, take them to a suitable area of the facility. Request that your legal counsel be on call. This is really important. I've had clients call me as soon as the inspector shows up, and that's great. And then I know I need to be at my desk for the next several hours until the inspection has concluded. And if any issues arise, they certainly call me during the course of that inspection, and I can provide guidance. And that's also handy to let the inspector know, because then it makes sense. There's an answer. There's a reason why you won't be able to give an answer right away. I've got to go call my counsel. I'll be right back with an answer to that.
As far as suitable area, this is really critical. You want to make sure and escort the investigators when they arrive to an area of your facility, probably a conference room towards the front of your facility, a waiting room, where they're not going to have access to any of your records. If they're left unsupervised, they're not going to have access, because they will look to binders, boxes, computers. Don't leave them unsupervised with any company records while they're waiting. And the other thing, and it's not on the slide here, but instruct, whether it's a security officer who's greeting someone at the front door or a receptionist, not to ask for the investigator's credentials when they walk in, because that will initiate the start of the investigation as soon as they provide their credentials. And now they're on the clock, and they're going to go see whatever they need to see. You can ask for a business card and then escort them to wherever you're going to keep them. And then whoever is greeting them, whether it's a receptionist, security guard, they need to then contact the entirety of the inspection team, contact the designated individual, say, so-and-so from the FDA is here. I've got their business card. They're waiting for you. And then don't delay. Don't run around and chat folks up and call counsel and wait and think, I really don't want to get this started. That's only going to antagonize the investigator as they sit there and wait, particularly as they sit there and wait in a room where they have nothing to look at. And so make sure that whoever's greeting is contacting the inspection team ASAP so that you can get out there and get started. But once you start verifying credentials, that is going to begin the process.
And it's okay to ask, what is the purpose of this inspection? Why are you here today? And the answer may be as simple as, it's a routine inspection, or they may say, we're here because we received a complaint. They'll tell you why they're here, and frankly, that can give you good information to know how to handle the particular investigation. And it's last point on the slide, it's important that you let the FDA know that I've got these policies in place, I've got to make sure that I'm following them, and so that they understand that there is a reason for what you're doing, that there's a logic behind your action.
And on the purpose of inspection, that should be documented on what's called a Form 482. That's going to be the notice of inspection. So they should provide that to you at that pre-inspection interview, and you should ask for a pre-inspection conference just to go over these things before the FDA investigator begins their inspection of the facility. So moving on to what to do during the inspection, this is policy number 1 in your inspection manual. Affidavits or statements, don't sign anything while they're there. Don't comment on the statements. Don't make any verbal agreements that you're going to do anything particular. Whatever may be prepared by the FDA investigator while they're there, affidavit, statement, whatever, get a copy of it and let them know that you're going to share it with your legal counsel for review, and that under your policy you are not permitted to sign anything. And by you, I mean whoever your designated individual is, not permitted to sign anything during the investigation, during the inspection.
Yeah, and on the photography point, so get copies of whatever it is that they're writing. Ask to make a copy of their notes. It's also okay to ask, if you do allow them to take photography, it's okay to ask for copies of the photos. Likewise, though, if they are taking photos, if that's permitted in your policy, it always makes sense to take photos of whatever they're taking photos of. So if you see them snapping a particular photo of a particular component of a machine, take a photo of that as well. It's good to know what they are looking at, and then we can figure out why they're looking at it later.
So there is no express legal authority for the FDA investigators to photograph your facility, but they will tell you that they have the authority. And looking at literally the FDA's Investigations Operations Manual actually lists case law that they direct investigators, if management refuses to allow photography, provide them with the following citations. And then they list out cases that they think support this position. It is an unresolved issue, but there's no express statutory authority to do that if you do not want to permit photography. And probably the biggest reason why not to is if you have trade secret material that may be visible within your facility, confidential business information, then make sure that that's a policy so that your inspection team can say, we have a policy, we don't permit photography, and then if they continue to push back, you can make a decision on whether or not it makes sense to go ahead and allow them to do this. It's really a question for your inspection team to judge whether it's going to antagonize the investigator or not. But they may say, all right, that's fine. They may push back hard and say, no, we're going to be able to do this. But the biggest reason why you might be concerned about it is whatever ends up in that file from the inspection is going to be subject to FOIA, which means your competitors can file a Freedom of Information Act request and obtain your FDA inspection file and know whatever the FDA recorded from their inspection of your facility. So if there are photographs in there of your confidential business practices, your manufacturing processes, those may be viewable via a FOIA request unless you cleared up what is and isn't trade secret. So that's one of the reasons why you may push back on that.
And a lot of our clients treat for instance, the entirety of their line as a trade secret. So you don't want an inspector to come in and take a picture of your line and then have that be subject to a Freedom of Information Act request. So one of the creative ways we've resolved a situation where the facility says, I don't want you to take photographs. The FDA says, we want photographs. We're between a rock and a hard place, is to allow photographs, but only of discrete components, such that they are pieces of a puzzle not put together. So there are creative ways that you can deal with these problems, but it's important that you understand the problems so that we can deal with them.
Go ahead.
Just to finish up on these, we can go through these slides pretty quickly because we've talked about a lot of this, but the questioning of employees, similar to the photography, there's no express legal authority to do so. Again, they will tell you that they have the authority to do so. Push back on that, and to the extent that you have a policy, it makes it much easier to do so. And there is a difference, of course, between non-managerial employees and managerial employees. If they're asking one of the line workers, what do you do on XYZ date? I typically would say that should be prohibited, and you should have a policy that says that it is prohibited. That makes it pretty simple. Don't volunteer anything. You want to be polite. You want to seem reasonable, but now is not the time to tell your life story. Minimal conversation is better.
And as far as managerial employees, the other concern there is that statements made by managerial employees might bind the company. And so the FDA might consider that an admission or statement of the company that they later hold you to down the road. Trade secret confidential information, real quickly, as we mentioned, important to designate that. And anytime the FDA is either taking a photo of something or they are asking to take copies of documents of your records that includes confidential or trade secret information, you want to make that clear to them that you want that designated, and then have a stamp added to that that says it is confidential trade secret, so that it's not going to be subject to a FOIA production down the road if someone asks for your inspection file. Records review. The FSMA statute has certain record-keeping requirements. Won't dig deep into this, but that's going to include your written food safety plan, hazard analysis, records that document the preventative controls you have in place for things like, food safety contaminants as well as allergens, monitoring corrective actions, verification. These records all have to be kept for 2 years. The FDA probably won't ask you for 2 years of records. They'll probably ask for the last several months. But you want to make sure that these things are all stored in a manner that's accessible so that your inspection team is able to access these things and get whatever it is the FDA is asking for. And then to make sure you keep copies or ask for copies of everything that the FDA is provided. So if they say, I want this, and this, you want to have your own copies of that so that you have a record of what was provided. And then they're also going to inspect your facility visually. That's going to be during a walk around there. And then there's going to be a sampling and swabbing test, if you will. They're going to pull out their swabbing materials, and they're going to be looking everywhere. Obviously, the big things that they're going to be looking for, your salmonella, your listeria, the ones that cause major food safety and illness concerns. But they're going to be collecting samples everywhere from your manufacturing line all the way to your break room vending machine to see if there is any place that a contaminant may be getting into one of the zones of your facility.
And we will start to pick up the pace here pretty quickly because we're way over.
1 or 2 minutes.
Okay. So we won't get through all of the materials. You've got the materials. If you have any questions about it, feel free to shoot either Guy or I an email or give us a call. But we'll just very quickly, probably goes without saying, but don't let the inspector into your facility unaccompanied. Make sure that there is a designated person to follow them around throughout the entire inspection.
And if you can, correct deficiencies during the inspection. I mean, if there's garbage on the floor or a puddle on the floor that's a danger or whatever it might be, don't just say, oh, and then move on. Call someone else to have that fixed if it's something that can be corrected while the inspectors are there. It's a simple thing.
We've covered most of everything on this slide. Be professional and courteous, but don't volunteer. Go ahead.
Can I go back to the swabbing?
Sure.
What is your feeling about the company duplicating the swabs or not?
The verdict is out on that. We've actually had discussions internally about whether that's a good idea. I've had clients that have done that. The positive side of it is that it creates an alternate record, and so if there's some discrepancy between the FDA's testing and our records, then we can help settle that. But also the downside of it is it creates an alternate record, and if the FDA inspector knows that they're there, it will ultimately be discoverable. So it creates another point of information. The other positive part of that is it gives you immediate results. I know the last time I had a client in that situation, they did have a lab come in and swab everything that the FDA swabs. And I could tell you they were pretty relieved when they got their test results back sooner than the FDA that everything was clear. So there are positives and negatives to weigh. The downside is it could create discoverable information, but the upside is it gives you an immediate or a more immediate answer. And if your test results are clean and the FDA has come up with something not clean, you will have something to dispute, a basis to dispute it on.
Well, and it's especially there's a concern because you're increasing the chance of a positive result, right? And the FDA is going to want to know about whatever results that you had from the same samples. But on the other hand, if you're having to hold product because the FDA sampled product, which if they're taking samples of your product, you should not be putting that into production while you're waiting to hear back from the FDA's sampling, because if it does come back with a contaminant, you want to be able to tell them there's no risk to further production, there's no risk as far as distribution of that goes. So that can accelerate, your all clear if you've done companion samples, but it really is a weighing the risk question there.
That said, though, I would not release your product. I would wait for the FDA all clear before, even if your test results all come back all clear, I would wait for the authority approval from the FDA before you go ahead and release the product.
I've also read or heard that you should immediately, after they swab an area, clean and sanitize it, so that you can say if there was a problem with that point in the production process, it was taken care of at that point, and all the product is after be cleared to ship.
Absolutely. As soon as they have swabbed or sampled really anywhere in the facility, go through that whole process so that, if they come back, you can say, well, here are the immediate steps that we took to clean and sanitize that area, whether or not there was any contaminant in that area. I'm cognizant that we have run over time. There's obviously a lot of material to cover here. So if you want, maybe we'll jump ahead to our other presentations, because I'm conscious that we have folks who are here to hear a lot of stuff, but we can come back to some of the issues with FDA inspections at the conclusion, and we're happy to answer questions. Does that make sense?
Sounds good.
All right.
So next up we have Dan Catman, who will be talking about branding and trademark issues.
All right, well, good evening, everyone. Completely 180 degree from FDA inspections. I'll try to make it as scary as FDA inspections sound, just to keep the interest level high. So my practice is really around advertising, branding, how to build your business and use your brand as an asset to prevent consumers from being confused in the marketplace. And I would say among all of our food and beverage type of customer or clients, their brand is usually one of the most valuable assets. And part of my job is to help clients pick pick good trademarks, get those trademarks protected so that they're enforceable, and then have sound business solutions if someone infringes those trademarks. So that's really the focus. I do a lot of advertising related work, so whether it's related to labeling, false advertising, anything that might involve sort of your package, so to speak, whatever is on your package. I do a lot of review on that. So we'll jump into this. So the focus of my presentation is really going to be on how to, what is a good trademark versus what is a bad trademark, and how should you go about selecting trademarks. And the reason why I say this is because a lot of clients come to me and they have a name in mind, they have a brand that they've thought of, and in their mind, this is the best trademark they've ever conceived of. And sometimes I have to break bad news to them and say it's either already taken, or even if we can get a trademark, it's just never going to be enforceable. In 3, 4, or 5 years, you're going to be one of 80 other people using the almost identical name, and you're not going to have any distinctive value in the marketplace. So the fundamental thing that everyone needs to understand about branding in the United States is that all trademark rights are based on use in commerce. So if you come up with a brand idea, but it's not on a package, it's not used on your website in connection with the service, you don't really have any trademark rights. So you see on TV in a lot of comedy situations where a character will say something witty and say trademark. Well, that doesn't really give them any trademark rights. You have to take steps to actually obtain those rights, and the first step is use. So in the United States, we have two competing areas or forms of use. We have use without a registration, and then use with a registration. And the use without a registration is often referred to as common law. So if you were to come up with a brand, put it on your package, start selling that product, you now have enforceable trademark rights, even though you don't have a registration. The problem with that is it's difficult to enforce those rights. So in the U.S., the benefit of getting a registration is it gives you nationwide protection immediately once it's registered, and it serves as evidence of what your rights are. So that's the main benefit. I'm not going to go into great detail on every slide just to keep things moving on a time standpoint, but there is nothing wrong with you starting to use a trademark without a registration and testing the waters. But realize that you may not be able to enforce it as easily as if you were to have a registration. At the same time, you can go out and get or try to get a registration, but if you don't start using the trademark, that registration is unenforceable. It has no value to it. So that sort of begs the question: when and why should I seek a registration of a trademark? So the first is the registration can help you preserve rights. So if you come up with an idea, but you're a year out from launching that product, we can file an application based on what we call intent to use. And while that application is pending, you now have time to do research and development, manufacturing, distribution agreements with distributors, whatever you need to do to get that product released into the marketplace. You have the time to do that without the risk of somebody coming in and taking that brand from you or jumping the gun and beating you to the marketplace with it. So that's what we call an intent to use application. That's a sort of an offensive tool to preserve a name. The next is to determine what is the value or the purpose of this trademark. It really needs to distinguish your brand from something else. So if you have a name that describes the product, it doesn't really brand the product like Apple Computer or Xerox or think of any sort of brand that you equate to a company name versus a name that describes the product. You have to really ask which one of those is your brand. If you are just coming up with a descriptive term for the product, it's not really a trademark. It's just a descriptor. So if you have come up with a brand that is distinctive, that identifies the company or the source of the product rather than just describing it, then that might be something worth pursuing as a federal registration. I already talked about whether it's in use or not. The next question is, how long is this brand going to be in the marketplace? If your marketing people say, we're going to do a short run of a product just to see if people like the flavor. So we're going to do a short run, maybe 6 months. Well, that may or may not be the best time to seek federal trademark protection because it's going to take at least 9 months to get the trademark registered, maybe even 12, 18 months. So if the product it comes and goes before the trademark gets registered, maybe it's not really worth going through that process and registering it. The next is it a good or a product or a service? And things like concepts or beliefs. I've had clients that say, our philosophy on how we treat our customers or our methodology and how we manufacture products, those aren't really brands. Methodology, a concept, a philosophy, that is not a product or a service and therefore cannot be protected. So if you've come up with an internal way of motivating your employees, not really a brand, not really something that we can register. So what if we don't seek registration? As I mentioned before, common law rights are limited. They are enforceable. The Federal Lanham Act does allow you to enforce any right that you have based on use of a trademark in commerce. But if it's not registered, your rights are limited to the geographic territory where you sell that product, or maybe the channel of trade. If you're wholesale only and a competitor is using a similar name at the retail level, you may not be able to stop them because your channels of trade are different. And common law rights would be confined to your narrow scope of use generally. The other aspect is there's this concept of first to file. So in the United States, you have these common law rights that arise from use of the trademark in commerce, but someone could file a trademark application before you do. And even though you predate them in the marketplace, they get their registration and you're left essentially being boxed in. So the example is this. If, let's say you come up with a brand name and you only use it in Wisconsin. A competitor comes up with a very similar brand name. They use it, let's say, in California. They get their registration while you're still in Wisconsin. Maybe even if you've expanded into Illinois, they get the registration. You are now confined to that market that you were in at the date of their obtaining that registration. And that means you can no longer expand that brand outside of that territory without infringing their rights, even though you predate them. And so that's one of the main reasons why, what the risks of what happens if you don't file. Outside of the United States, the majority of the countries are what we call statutory countries, meaning if you don't have a registration, you have no rights. The only exceptions to that are the United States, Australia, and the United Kingdom. Every other country is a statutory country where if you don't have a registration, you have no ability to enforce that right. We run into this problem in China frequently, where we will go to China either to obtain a manufacturer or actually to even sell a product, find out that a squatter who is not involved in the industry at all has obtained a Chinese registration for that trademark, and now they have held us hostage. Our distributors are held hostage. They infringe that the squatters' trademark rights. We've even had the squatters confiscate or impound our clients' products through Chinese customs just with that registration that they've obtained. So registrations outside of the United States, Australia, and the United Kingdom are absolutely crucial. There's also sort of this prize in the United States, and the U.S. is the only country that has this, and that's called incontestability. So if I obtain a trademark registration and I continue to use that trademark for 5 years in the United States after the registration has been obtained, I can file a declaration at that 5-year mark and make my registration incontestable. And that means that even if I'm infringing somebody else's rights, let's say they had common law rights and they didn't get around to filing their trademark, that I did, and now my registration is incontestable, they cannot invalidate my trademark unless they can show that I committed fraud or they can show that I've abandoned my trademark. So that's this prize that you can obtain with a registration that is unique. Let's see. So the next main focus is, as I mentioned, not all trademarks are created equal. And this is really an important thing for you to understand when you talk to marketing people. Someone might come up with a great idea and say, hey, let's get this trademark. But the reality is some trademarks are better than others. So we have sort of 3 different categories. We have what we call inherently distinctive terms. Those are the good trademarks. We have descriptive terms that describe a feature or a component of your product or service. And those may not be protectable immediately, but may over time become protectable. If you spend enough money in advertising and no one else is using that same term, it's possible after 5 years that you now have an enforceable trademark. And then the third category are generic terms, and those can never become trademarks, ever. No matter how long you use them, no matter how much money you spend, they cannot be protected. So when I work with clients to protect their trademarks, we go through this process. What is your trademark inherently distinctive? Is it descriptive, or is it generic? If it is inherently distinctive, and here's the 3 forms of that, we can go ahead and file the application right away and are relatively confident that we're going to get it registered without a lot of hassle unless it conflicts with somebody else's pre-existing rights. And I won't go through this in great detail, but there are essentially 3 different types of inherently distinctive trademarks. Then we have the weaker trademarks, the descriptive trademarks. And descriptive trademarks fall under a couple different categories. One is we have something that's what we call merely descriptive. It merely describes an ingredient, a product. If you have, let's say, almond milk, for example, as a brand name, and if the milk is, or the drink is made from almonds, well, now that's a descriptive product. Almond milk describes the product. On the other hand, if that drink does not contain almonds, it's what we call misdescriptive. And that, too, is also not capable of being registered because it misdescribes the product. So those are the trademarks we want to avoid. If you come up with a sort of a unique name that describes a feature of the product, it is possible to still get a registration. And that's what we call a supplemental registration. But what you're essentially doing is you're admitting to the world that this is not a full, valuable trademark that can be enforced. And those are, that becomes a public record at that point. If you file an application that's rejected on the grounds of descriptiveness. Other examples are like surnames, so your last name may or may not be protectable, depending on how common it is. If you're trying to go out and get the word Smith registered as a trademark, it may be very difficult. It is possible, but not necessarily easy. Geographic locations can be descriptive because it describes the origin of the product rather than distinguishing the product. And then laudatory terms like great or best, those are generally difficult to protect as well. However, if you do have a descriptive word, you can become registered after 5 years if you can show that you've spent enough time and energy and money to convince consumers that this trademark is indeed a trademark. If it is misdescriptive, it doesn't matter how long you use it, you'll never be able to get it registered. But let's say you've used the word Smith for your company name for 5 years, you can now reapply with the Federal Trademark Office and say, I've used this trademark long enough that consumers know who I am, and now it's a distinctive brand and can be enforced. So let's say you've come up with a good trademark. I've told you, you've run it past me, I've done a search, and you're not going to infringe anybody else's rights. It's not descriptive. I think you've got a good chance of getting it registered. One of the main things that we want to do is do a clearance search to make sure that you're not going to violate anybody else's rights. And there are sort of 3 risks that I want to look at when I do a clearance search. The first is infringement. You don't want to use a trademark that is going to infringe somebody else's existing rights. And we look at other people's registrations, and we look to see if other people are just using a trademark without a registration to see if they're going to violate those rights. The second is procedural. So let's say you're not going to violate anybody else's rights, but the trademark is descriptive or laudatory or misdescriptive. I'll just say, look, we're not going to be able to get the trademark registered for procedural reasons. And that's a risk because you now need to decide, is it worth using this trademark without a registration? And you may say, yeah, it's fine. We're willing to use this brand knowing that we're never really going to be able to enforce it easily across the country with a registration. And then the third is value. In that search, I may say, look, you're not going to infringe anybody else's rights. We can get the trademark registered procedurally, but once it's registered, you're going to be one of 20 other companies out there using essentially the similar trademark on related fields, related industries, and you're going to be constantly trying to distinguish yourself in the marketplace. Every advertising dollar you spend will be spent saying, we're this company. Don't confuse us with that company. And that's not a good use of marketing and advertising dollars. So a good, strong trademark is actually easier and less expensive to market and advertise than a weaker, more descriptive trademark for that reason. I won't go into great detail on different types. Some of this information are things that you can just read through, but you can get a trademark on a word, a design. You can get trademarks on smells, sounds, colors. It all comes down to whether or not that brand distinguishes you in the marketplace. The other key thing to focus on is how are you going to be using this trademark? When we file a trademark application, we have to show evidence of how it's going to be used. And the Trademark Office requires us to submit specimens showing how that's going to be used. And If you change how that trademark is used from the time that we file to the time that you actually use it, we may have to start the whole process over again. And this is just an example, a real world example. A client of mine is all public on the U.S. Patent Trademark Office database. We filed Mojo Bowl that would be on the left, and the O has sort of sun ray beams coming out of it. By the time my client began using the trademark, the sunbeams had become those lines that you see on the right. So the Trademark Office rejected the application saying, well, the trademark is no longer the same as what you filed it for. And we had to then argue with the Trademark Office saying, look, that's not a material change. You know, essentially the logo is the same, except the sunbeams are different. And you're not required to do another search. Consumers aren't going to think that the lines on the right-hand side are something other than sunbeams. So that process increased the time and the cost of obtaining that registration because our client changed how they were using the trademark. If you change it too much, it may be impossible to get that trademark through to start the entire process all over again. So when you pick a name or brand, you need to just stick with it, knowing that you may not be able to change it, or if you do change it, you'll have to file another application for it. Common question I get frequently are notices. So if you're using the trademark without a registration, you can use the TM symbol or the SM symbol, trademark versus service mark. There really aren't a lot of laws about the use of those symbols. You don't have to have an application pending to use TM or SM. So if you just come up with a name and think that it has some trademark brand value, use the TM. You don't have to call me, you don't have to file anything, just use it. Now, the flip side of that is it doesn't really mean anything. It doesn't give you rights. It doesn't allow us to enforce that trademark any better than if you didn't use the TM. But sometimes it does put people on notice that you think that this is a trademark and they may be in trouble if they use the name. Once we get the trademark registered, that's when you can use the circle R symbol. And it's only at the time of registration that you can use that symbol. If you use the trademark, the R symbol, before it is registered, that can actually prevent you from enforcing that trademark against an infringer. It's actually fraud against the Trademark Office. And a infringer could say, look, they are claiming that they had a registration when indeed they didn't. And you can have your case dismissed on that ground. So don't use the R symbol unless we have told you, or your trademark attorney has told you, you now have a registration. Here's the certificate. So finally, kind of wrap things up, we have, you get your trademark registered, or you decide to use a trademark without a registration. Either way, if you don't use that trademark properly, you can lose your rights, even if it's registered. So if you use your trademark descriptively, so even if we've told you, the Trademark Office doesn't view it as being a descriptive term, but you use it descriptively to describe your product. For example, if I'm going to go out and Google something, I'm using the word Google to describe what I'm going to do, that can cause the loss of your trademark rights. So on your packaging, you don't want to use your brand descriptively. You also don't want to use it inconsistently. If we obtained, Quickie Mart with a K, don't mix it up and use it with a C or use it in different ways, because that inconsistent use will weaken the ability of you to enforce your trademark. The other thing is using it on the improper goods. If we have a trademark, let's say, on beer, but you stop using it on beer, now it's only on wine, you may now effectively abandon the rights that you obtained, because those rights are based on beer, not wine. And then finally, incidental or sort of infrequent use. If you bury that trademark on the back of your package in 2-point font, it's probably not going to rise to the level of use. So you can't just use what we call token use or use just to try to maintain your trademark registration. It has to be actual bona fide use of the trademark as a brand that your consumers would recognize. That's about it. Any questions, any areas you want me to focus on more specifically? All right.
Next up is Kate Westfall, who will talk about some recurring corporate problems that she sees in her practice.
Okay, great. So I work in the firm's business and corporate department. work with small business owners, also do a lot with investors in the venture capital area. And so today I'm going to talk about profits interest and how you can use as a business owner a profits interest to not only retain key employees that you have, but also to attract new employees that you might want to hire. The second thing I'm going to talk about is just some general insights and overviews on raising capital, and then this new thing that's finally made its way to Wisconsin, which is a state agreement. And then I have up here, and as we were kind of allotting the different time periods, I don't actually have enough time to talk about the operating agreements, but I do have an article that's going to come out excuse me, in August, so we'll make sure that everybody gets a copy of that. So, turning to the profits interest. How do you use them, and why does the company use them? From a company perspective, what a profits interest allows you to do is offer equity to an employee, but then preserve all the value that you've already earned or established in the company. From an employee's perspective, what a profits interest allows you to do is get equity in a company without actually coming out of pocket for even $1. The biggest thing that you want to think about when you have a profits interest is the vesting. And so one of the vesting is time vesting. And so when you make a grant to your employee and you need to figure out on the day that you grant the interest to the employee, does a portion or all of the profits interest vest at that time, or does it vest at some point down the road? The other thing to think about is how long should the vesting schedule be? So typically, if you have an employee and you're trying to retain that employee, you already, you have a background with the employee, you have experience with the employee. So when you offer the grant to that employee to try to make them stay, you want to offer some portion of that grant should vest immediately on the day that you grant it. And then every month or every quarter thereafter, for a period of about 2 to 3 years, another portion or allotment of the profits interest would continue to grant. On the flip side, if you're trying to retain, or if you're trying to attract a new employee, so it would be somebody that you don't really have experience with, it would be somebody whose track record maybe you're not that familiar with, there's a little bit of risk if you offer if you vest as soon as you grant. So in that instance, it might make sense to bring the employee on, grant them the equity from the profits interest, but not have any of that profits interest grant for maybe a period of a year, sometimes even a period of 2 years. So it's essentially acts as a trial period. And then as soon as the first year goes by, a portion grants or vests, and then every year after, another portion vests. But again, if you're in that situation where you're attracting an employee that's new and you don't have a track record with, you probably want to extend the full vesting period from something from 2, maybe even all the way up to 5 years. So essentially you have a 5-year period where you're trying that employee out, and at the end of that 5-year period, the employee will be fully vested. So, yep.
So is this a new term or a new concept? This is different to stock options, right?
Yes, so it's different.
It's a cash option back. Is that what it is?
Well, so a profits interest is available to an LLC, whereas an incentive stock option or a restricted stock option would be available in the corporate context. And so when you...
so only available to an LLC?
Correct. And so the reason why that there's a tax advantage for the employees, or the employee doesn't come out of pocket for even $1, is because in the graph that's up there, you create a threshold value, and the threshold value is the fair market value when you make the grant to the employee. So let's say in the example up here, the threshold value today of the company is $5 million. So you have that value that you've already established in the company. The threshold value is $5 million. Thereafter, the value is going to continue to grow, but the employee who's being given the profits interest only participates in the distribution above the $5 million threshold. So in theory, if the day that you grant the person the interest, you sell the company for $3 million, in our example, that employee gets nothing. If you sell the company the next day for $5 million, which is the threshold value, the employee gets nothing. So in theory, from the tax perspective, the employee isn't receiving anything of value on the day that you grant them the interest. So then if you keep going with that example, if you sell in 2020 and you sell for $10 million, then the first $5 million is going to go to the founders. Above the threshold, the employee is going to jump in and he's going to participate on a pro rata basis in anything that's above $5 million. So it is different from a stock option, and this is only available to an LLC. Yeah. So aside from time vesting, which would be monthly or quarterly or annually, the other option would be performance vesting. In performance vesting, you would just pick if it's a certain revenue threshold, a certain income that you want to have for recurring for years, whatever it is. The interest would vest when that happens or when that goal is met. So then the next thing to think about is, what happens if you grant an interest and then you fire that employee, terminate the employee, or the employee resigns. And that's where you want to make sure that you have a repurchase right. So they work in concert with forfeiture rights. So let's say, for example, you've got, you are hiring a new employee who's the director of sales, for example. So you've got that 1 year waiting period before anything vests. If that employee leaves or you terminate that employee before anything vests, all the unvested interest should be forfeited. So then in this example, if you continue it, let's say you fire or the employee resigns in year 2 after 50% of his interest is vested. The 50 that are unvested will still forfeit, and then you want to make sure that you as the company have the ability to buy back the portion that's vested. And the reason for that, which might not be obvious, is if you keep that employee on your cap table, even if he or she only represents 1 or 2% of the company, if you fast forward and you sell the company for $50 million in 20 years, that employee, even though they were only at the company for 1.5 years or 2 years, they're still going to participate in all of the growth that was achieved above the $5 million. So essentially, it's just a massive windfall for that employee if you don't have the ability to buy back the shares. Some of the other things I have on here is just a change of control. So typically, if there's any portion of unvested shares or units that are outstanding when you sell the company, those typically accelerate, and the person would be fully vested on the day immediately before you close that change of control. Form 83B is just a reference. It's a form that the employee would file with the IRS to make sure that he or she has favorable tax treatment on the profits interest. Do you have any questions on how a profits interest works?
Commonly used.
It's huge. It's huge. So just in the last month, we had a profit. We were helping a company. It was a pasta company working out of the suburbs of Chicago. They had been around for 8 or 9 years. They were cruising, and they wanted to use it to incentivize an employee who had just been an employee but not a member. So we used it there. We also just used it for a beverage company up in Cedarburg, and theirs was a little bit different. It was a husband and wife. Same thing. They were at the end of the runway, and they were about to take off, but they needed to hire somebody to help them with sales. And so they had narrowed it down to 2 folks that they wanted to hire, both of whom said, we're not coming on board unless you give us equity. And so, again, to make sure that they could retain all of the value that they had already built up, the profits interest was the way to go. Yeah, I would say we do this every other week or so.
On this LLC portion, is this used as a way, you talked about equity.
Yep.
Is this a way, if you're going to sell the company, to grant a potential buyer the equity interest that they may need to make that transaction?
Can you just elaborate just a little bit? I'm not sure I caught that.
So acquiring a company.
Yep.
And you're thinking, you've got this person pegged as a potential future owner of the company.
Okay.
A way to create a transition of ownership and an easy way for them to build the equity and that some transactions tough for an individual.
Oh, I see. So if you identified a potential buyer and you didn't think the buyer had the cash to come out of pocket, I think from the business owner, you'd rather find a buyer that did have the cash. But I think if you're trying to transition and the buyer isn't just a random third party, and instead it's somebody internally who you anticipate kind of turning the business over to, I think it might make a little bit more sense from that perspective. But no, if you own a company, I think the best way to do it is, I mean, you'd want to realize the value on the sale up through the full amount of the fair market value on the day that you close. And so you wouldn't want to carve out any kind of built-in interest below the threshold value. All right, so then we'll move quickly to capital raising. And again, in my practice, I work a lot with emerging companies, but also with a lot of investors. And the biggest thing we get around both sides of the table is people who don't, when you think about raising capital, the first thing that should come to mind when you're pitching is how are you going to exit? How are you going to get the investors their money back? What is going to be the multiple on the money back? And how quickly are they going to get their money back? So just kind of keep that in the back of your head if you ever are in that situation. The other thing we always get comments on, is the number one thing that bugs investors, is when they read a business plan, they have financials that are just so outlandish that it's hard to even take the business owner seriously. And so what we recommend people do now is they create 3 sets of financials. The first set is the incredibly conservative set of financials. The next set is just the average set of financials. And then the third would be the absolute best case scenario. And we always have the caveat that whatever financials are currently in the business plan, those should be the incredibly aggressive financials, and everything else should be pared back from there, just so that you can prove out and actually stand behind the numbers that you have.
So what is the rule of thumb? How quick do they get their money back? What do they want as a multiple?
Yeah, it depends on who the investor is and where the investor is. So with the Wisconsin investor, typically it's a little bit more conservative. They're not beating down your door trying to get your money back in 3 or 5 years. If it's an investor on the coast, or even some of the investors out of Chicago, especially some of the funds, the angel funds or the VC funds, they're going to expect their money back in 5 to 7 years.
What kind of multiple?
Again, it would depend on where you sit in the food and beverage company. If you are an actual producer versus the manufacturer, if you're in food versus if you're in beverage, but anywhere from 6 to 15, I'd say. It just depends.
Kate, do you want to talk about the safes?
Sure.
I think that's an underappreciated new development.
Yep. So the SAFE, it's an agreement that stands for Simple Agreement for Future Equity. It started on the coast, Silicon Valley, finally made its way here, and it's really taken the place whole hog of the old school convertible notes. The difference with a SAFE is that it doesn't have an interest rate, so the company doesn't have to worry about one, just administratively keeping track of the interest payments from the investors, but also coming out of pocket and paying the interest payments. And then secondly, it doesn't have a maturity date. So in 2 or 3 years, the company wouldn't have to be concerned with having to pay back all of their investors. So instead, what the SAFE does is it allows the company, I'll give a real world example. So we have a client now who's in the non-glass drinkware category. She needs $250,000 to get a mold to fulfill all the pre-orders that she has, which is almost $1 million. And she also knows that she needs a follow-on of about $1 million. So the issue she's in now is, to get that $250,000, does she put a value on her company and take straight equity to get the $250,000? If she did that, she would probably only be able to value the company at about $1 million. So if she took in the $250,000 and $1 million, she's giving up about 25% of her company. She knows in the long run that her company's worth a heck of a lot more than that, but it probably can't substantiate much more than the $1 million value today. So instead what she did is she took it through a SAFE note. So she took the $250,000, she's got it in her bank account, she's already ordered the mold, and she's fulfilling all of her orders. In a year from now, or 16 months from now, she's going to go to the VCs, and her valuation is going to be somewhere, hopefully, around $10 million. So what happens with the 250 that came in today is they're going to piggyback and they're going to roll into that valuation of $10 million down the road. So instead, if she had taken in the 250 as straight equity, she would have given up 25% of her company. Instead, she's going to do it down the road, and she's going to end up taking in that same 250 for about 3% of her company. So it just saves her a huge headache, but it gives her the cash flow that she needs today. And the same would be true if she took the 250 today and tried to justify a $10 million value, and you fast forwarded and the VCs only came in at 5, she would have the reverse problem that she undersold her securities.
So is it a convertible with some form of cap? Exactly what it is.
That's exactly what it is.
So the interest and the maturity.
It's exactly what it is. So it can have two different features. It can have the discount, which is really common here in the Midwest. It can also have a cap. And so essentially what he's saying is, when you give your 250 today, it is not in your best interest that the company is worth $100 million in a year. Because then your 250 is worth so little compared to what you thought it might be, that you put a cap on it. And so you say, I'm going to give you 250 today, but you cannot value the company for more than $10 million in the future. So you at least preserve some percentage interest in what you're trying to do. But that's right. And the caps aren't as common in the Midwest. You see them a ton in Silicon Valley, Austin, New York, those type of fast-paced, innovative hubs. Not so much here.
So in 5 years, the government's only worth $1 million. She gave away 25% of her company.
And either way, she would. And the reality with that is, then that is the actual value of the $2 million that she took. The issue and what the state solves is you trying to guess what the value is, and then either being high, and then you essentially are not being fair to the initial investor, or you're incredibly low, and then you're not being fair to yourself. Yeah.
Thank you, Kate.
Yeah.
And thank you, all of you, and thank you all for coming. Just as a heads up, we are expecting to have another food and bev event probably in the fall aimed at recalls. So keep your eyes open for that. If you are not on our mailing list, let us know and we will get you on the mailing list. With that, again, thank you for coming, and please enjoy some food and beverage.